Hello and welcome to this webinar on handling disciplinaries. My name is Louise Holloway and I've been an HR and training specialist for well over 20 years. And over my career, I've worked with a range of businesses of all different sizes, based both in the UK and internationally. And my passion is supporting managers and organisations in getting the most out of their most important asset, their people. Today, we're going to be focusing on what steps a manager needs to take when faced with a potential disciplinary situation and some of the legal hurdles around it. The webinar is being recorded and will be available on my website shortly after the session. I'll start by giving a presentation on the topic and then we'll answer any questions that you may have. So if you do have any during the presentation, please make a note of them and we'll get to them at the end. Right, let's get started. Disciplinary proceedings are intense. And to be honest, some managers will do anything they can to avoid the process. Unfortunately, if poor behaviour in the workplace is not addressed, then it can lead to much bigger problems, including continued issues, loss of revenue, loss of reputation, and ultimately grievances and employment tribunals. In this webinar, we'll be aiming to firstly set out the law and the best practice on running disciplinary procedures, identify the best preparation for a hearing, and provide guidance on conducting the hearing itself. Throughout the webinar, please keep in mind that the aim of disciplinary action is always to correct poor behaviour, not to punish or intimidate. It is not a stick to beat people with. Firstly, we need to think about why we should follow a disciplinary process and what the risks are of not doing it properly. Unpleasant as it is, there are many benefits to having a fair and consistent disciplinary process. Having and using one helps to ensure that employees are treated fairly and consistently. It encourages improvements in behaviour and or performance. It signals company expectations to all of the team. It helps to avoid the company going to employment tribunal and saves on costs, such as improved productivity, reduced labour turnover, and ultimately the cost of going to an employment tribunal. On the other hand, the risks of not handling disciplinary issues can be both directly and indirectly costly. Failing to follow up on issues effectively can cause emotional stress for the employees involved, cost more in managers' time dealing with the issues, and affect the morale of the team. In the worst case scenarios, you could end up having to go to employment tribunal, pay costs and compensation, reinstate a dismissed employee, and face the bad publicity that follows such a case. Now, before we go any further, it's important to clearly identify when the disciplinary process should be used. To answer this, it's important to understand the difference between conduct and capability. Conduct is where the reason is within the employee's control. For example, negligence, lack of application, or attitudinal problems. Whereas capability is where the reason is outside of the colleague's control. For example, poor health, a lack of training, or the changing nature of the job. In this session, we'll be focusing on managing conduct cases, as capability issues should be handled through a capability or performance management process. When engaging in disciplinary proceedings, ACAS have developed statutory guidance which sets out best practice for managers to follow. Now, whilst failing to follow this code is not unlawful in itself, failing to do so will be examined by the court in an unfair dismissal case. and if employers are found to have unreasonably failed to comply with the code, it could lead to an up to 25% uplift in compensation awards. On the other hand, an employee's failure to comply could lead to a 25% reduction in any award. So it pays for both sides to be compliant. The code sets out the minimum best practice process a manager should take when carrying out disciplinary action and is available on the ACAS website. At the very least, all employers must set out in writing what their disciplinary policy is and what process they will follow. This can either be in the contract of employment or preferably in a staff handbook or policy document, and it must be easily accessible for all employees. This policy can either be in line with the ACAS code or contain additional rights. For example, the code says to hold a meeting without unreasonable delay, but your internal policy may state meetings will be held within 5 working days. Your policy should outline examples of the different levels of misconduct and what the potential outcomes could be. And we'll talk more about this later on. The important thing to note is that your policy should state that any examples given are non-exhaustive and that each incident will be reviewed individually. A failure to do so could lead to an employee rightly claiming that their act was not gross misconduct because it was not included in the list of gross misconduct examples within the disciplinary policy. So, what's the process? Well, as outlined in the ACAS Code of Practice, it's made up of 3 stages. Firstly, the investigation. This is the process of gathering facts regarding the incident and an assessment based on those facts of whether there is a case to answer. The next stage is the disciplinary hearing itself, and this is where the case is heard and appropriate corrective action taken to encourage and enable the employee to meet the required standard. And the final stage is the appeal hearing. If the colleague wishes to appeal a disciplinary decision, they'll be asked to confirm on which grounds they're appealing. These grounds will then be reviewed and a meeting held so that a final decision can be taken. Now, whilst I've said that we must follow a clear disciplinary process, we shouldn't always be in a rush to get there. Where an act of misconduct is not serious and has a limited impact on the business, for example, lateness, it's recommended to take informal action before moving to a formal process. Informal action is a deterrent. It is hoped that by taking an informal approach, the message will get through and they will not act in this way in the future. If they do, then formal action can take place. Informal action would usually involve a discussion about a minor offence, ensuring that notes of the discussion are taken and any evidence of the informal action is recorded in the employee's file. A letter of concern is then sent to the employee along with a copy of any evidence to ensure that they're fully informed of the standards required and the potential consequences of them not adhering to them. Should poor behaviour become more serious or not stopped via the informal process, then you will need to conduct an investigation. This is the fact-finding part of the process and is aimed at collecting all relevant information that supports or goes against the disciplinary actions. Investigations need to be fair and reasonable, and the more serious the allegation, the more thorough the investigation needs to be. For example, in Salford NH Trust versus Roldan, the Court of Appeal held that the investigation was inadequate because the employee faced possible deportation if she was dismissed. so the potential consequences were severe. The person carrying out the investigation needs to be independent and impartial. Wherever possible, there should be at least 2 senior, impartial individuals remaining within the business who can carry out the later stages of the disciplinary process. The investigator's role is to decide, on the balance of probabilities, whether there is a case to answer, based on all of the investigation information that they have in front of them. If there is a case to answer, they should then recommend that a disciplinary hearing be held. If there isn't a case to answer, the recommendation is the disciplinary proceedings should be dropped. Now, gathering all the relevant information may include holding an investigation interview with the employee to establish the facts, holding an investigation interview with witnesses or other relevant parties. It could be documentary evidence or physical evidence, for example, CCTV or computer records. All of the collated information should be kept together and, where appropriate, passed on to the disciplining manager, either as a file or a report. It is important to note that the investigating officer does not decide whether the employee has committed the act of misconduct or not. This is not their role. They are tasked purely with collecting all of the facts together and deciding whether there is enough evidence there to start disciplinary proceedings. When investigating an allegation of misconduct, it may on occasion be necessary to suspend an employee to protect either them or the business. However, this should only be done where it is necessary and not as a matter of course. Before making a decision to suspend, you need to assess whether suspension is needed to ensure that the matter can be investigated properly. This could be where you genuinely believe that the employee could tamper with evidence, or if the allegation is of a particularly sensitive nature, for example, sexual or racial harassment. Even then, you need to see if there are alternatives available. For example, the employee moving teams, restricting duties, or placing them under supervision. Suspension should only last as long as is needed for the investigation to be undertaken, as it can have a damaging effect on the employee, especially where they're in a professional role. If an employee is suspended, they should be provided with a letter, and that should include the reasons for the suspension and how long it is expected to last, their rights and obligations during the suspension, for example, if they're required to be contactable during normal working hours, a point of contact, such as their manager or HR, and the contact details for that employee. And finally, confirmation that suspension is not an assumption of guilt and that the purpose of it is to thoroughly investigate the allegations. Suspension should always be kept confidential, and it should be reviewed on an ongoing basis, including regular contact with the employee. If the decision is taken that the allegations should go to a formal disciplinary hearing, then the employee should be formally invited in writing, giving them time to prepare. Ideally, 48 hours or more before the planned hearing, and certainly no less than 24 hours. The letter should contain as much information as possible, including dates and times of alleged incidents, an explanation of the alleged misconduct, copies of any evidence that will be referred to, so investigation notes, CCTV, witness statements, computer records, emails, etc., and your company policy on this area. It also needs to contain the possible outcome. This allows the employee to understand the severity of the allegations that they're facing and prepare their defence appropriately. Giving a more serious sanction that the employee has been informed of is likely to be seen unfair in the eyes of an employment tribunal. In the letter, you should always make sure that the hearing date, time and location is clear. Confirm who will be present and what role they'll be taking, for example, chair or note taker, and confirm the employee's right to be accompanied. It's also a good idea to request their confirmation of attendance. It's crucial that the employee is provided with a copy of all documents and information that will be used in the hearing so that they can read these in good time, understand them, and formulate an explanation or defence. If new information comes to light at a later date, this should also be provided to the employee, ensuring there's still sufficient time for them to review them. Any employee asked to attend a formal meeting which could result in disciplinary action or dismissal is entitled to be accompanied by either a work colleague, a trade union representative, or an official employed by a trade union, whether you recognise that union or not. The companion can address the hearing on the employee's behalf, take notes on behalf of the employee, discuss and talk things over with the employee during the hearing, respond on the employee's behalf to any views expressed during the meeting, and sum up the employee's case. The companion does not have the right to respond to questions on the employee's behalf, address the hearing if the employee does not want them to, or prevent the employee from explaining their case. Overall, it's regarded as good practice for the employer to allow the companion to participate as fully as possible. Now, if the companion's not available for the scheduled hearing, then the employee should suggest an alternative time. If this is within 5 days of the original meeting date and is reasonable, then the hearing must be postponed. Where the alternative isn't within this period, there is no requirement to postpone. However, in Talon Engineering Limited versus Smith, the Employee Appeal Tribunal held that failure to allow a request to postpone a hearing to allow the companion to attend was unreasonable, and therefore the dismissal was unfair. Failure to allow for a companion entirely would make any dismissal automatically unfair. No one, however, is obliged to act as a companion, even if an employee asks them to do so. Next, we move on to the disciplinary hearing itself. When planning a disciplinary hearing, there are 3 key areas that you need to consider. Firstly, where it will be held, so the premises. Formal hearings should always be held in private, in a closed room with no interruptions, including mobile phones. There should also ideally be somewhere that the employee can wait during any adjournments without it being obvious to other staff why they are there. The second thing to think about is the people, so who should be involved. The key person is the disciplinary chair. Now, this will be someone who is impartial, independent, and who has not been involved in the process so far. You should also arrange for a note taker, who can be another manager or a member of the HR team. And again, where possible, they should have had no involvement in the case up to now. The other 2 people who will be present are the employee and their companion. The final thing to think about is the paperwork. You need to make sure that all of the witness statements, records, company policies, and evidence are available so they can be referred back to, questions, and any discrepancies discussed. You should also make sure that the note taker has appropriate pens and paper available to take the notes. When opening a disciplinary hearing, You should start by introducing all attendees by name and explaining their roles. You should then explain the structure of the meeting, where you are in the process, and confirm whether they have a companion with them, and if not, whether they're happy to continue without one. During the hearing itself, you should outline the evidence that has been collected and produce witness statements as necessary. It's important that you do not make assumptions about what the evidence means, but ask open questions and allow the employee to challenge the evidence and state their case. Remember, you are not looking to find them guilty, but to get the facts of what has happened and why. You should therefore ask them whether there is additional or mitigating information that should be considered and listen to it. You can adjourn the meeting whenever you feel it appropriate. If tempers get frayed, for example, or the employee becomes upset, you should always adjourn if new evidence comes up to give yourself a chance to further investigate it, and again at the end of the meeting before you give your decision. When you do adjourn, you should always explain to the employee why the adjournment is taking place, so they are not left feeling uncertain with the future process. If possible, confirm when the meeting is likely to be reconvened, or give an approximate timeline and confirm this as soon as possible after the adjournment. Once you've heard everything that you need to, you will need to adjourn the hearing to consider the outcome and whether or not any form of disciplinary action is appropriate. To decide this, you need to think about the seriousness of the misconduct, the explanation given in the disciplinary hearing, the organisation's policies, and any mitigating evidence. For example, the length of service and previous disciplinary record. You also need to keep in mind the potential outcomes that were given in the invitation letter. The potential action that you could take includes no further action. This is where you're comfortable that action is not required. A first written warning. This could be for a first time or less serious offence, like lateness. A final written warning. This could be either for a second offence or a more serious one, such as a breach of procedure leading to a loss to the company. It could be dismissal with notice, and this would normally be for a second or third offence. Or finally, summary dismissal, and this would be for gross misconduct. Generally, the levels of warnings are progressive, from first written through to dismissal, although more serious cases can lead to a more serious penalty. The most serious case is gross misconduct, which is defined as misconduct that is serious enough to destroy the trust and confidence between the employer and the employee. This breakdown in trust and confidence breaches the employment contract, making any further relationship impossible and normally results in summary dismissal. Examples of gross misconduct should be called out in your policy and can include things like theft, dishonesty, or falsification of documents or fraud, physical violence, intimidation, aggressive behaviour or bullying, acts of incitement to or acts of unlawful discrimination or harassment, misuse of the IT or computer system, failure to follow a reasonable management instruction, or inappropriate use of social media in breach of the company's social media policy. Again, make sure that you are clear that this list is not exhaustive. If an employee is dismissed for gross misconduct, then they are not entitled to any notice or pay in lieu of notice. They're therefore paid up until the day they're dismissed, plus any accrued holiday pay. Following on from the hearing, you should ensure that your decision is communicated to your employee. Depending on your policy, this can be in person, so after the adjournment of the hearing, or in writing. You need to be clear with the employee which way you're going to do this. As a minimum, you should ensure that the employee is provided with a letter explaining the disciplinary outcome, so what level of action you're taking, the period that warning will last. First written warnings, for example, commonly last either 6 or 9 months, and final written warnings may be 9 months or 12. The standards of future behaviour that are expected, the potential consequences of further misconduct, so the risk of further disciplinary action or dismissal for repeat offences, and the right to appeal and how they should do this. Notes of the disciplinary hearing should also be provided to the employee so they can review them and sign them as an accurate note of discussions. Employees have a legal right to appeal any decision taken against them. The opportunity to appeal against a disciplinary decision is essential to natural justice, and appeals may be raised by colleagues on various grounds. For instance, new evidence, undue severity, or inconsistency of the penalty. Defects in the original disciplinary procedure may often be remedied through a properly held appeal, and an appeal must never be used as an opportunity to punish the colleague for appealing the original decision. A good practice is that it should not result in any increase in penalty, as this may deter individuals from appealing. The appeal manager will, wherever possible, be senior to the disciplining manager and will have no previous connection to the case. They must always have the authority to overturn any disciplinary decision that's been made. The appeal is the last chance to correct any deviations from the correct procedure, so must be conducted with an open mind and closely re-examine the evidence. Appeals can either be a review of what has already happened or a complete rehearing of the case. You should always ensure that the employee is encouraged to provide reasons for their appeal. The appeal is arranged without delay. The employee is aware that they have a right to be accompanied, and the appeal is held by an impartial chair who has not previously been involved. And finally, the outcome should be provided without delay. The potential outcomes of the appeal are, firstly, that the appeal is allowed, and this means that the previous decision taken at the disciplinary hearing is overturned. The appeal manager can either throw out all sanctions or substitute a different one, for example, a first written warning rather than a final written warning. Or the appeal can be dismissed, and this means that the previous decision taken at disciplinary hearing is confirmed, and the appeal is the end of the disciplinary procedure. Now, whilst these are the basic rules of a good disciplinary process, there are some additional considerations for you to think about. Employers should be consistent in taking disciplinary action and in imposing a sanction for similar acts of misconduct. Disciplining managers should therefore consider any previous sanctions for similar offences. For example, in Fuller versus London Borough of Brent, the Court of Appeal found a fair disciplinary process had not been followed because an employee was dismissed for gross misconduct following an incident when a previous similar incident had led to no formal warning at all. Employers should also be consistent in taking action and imposing a sanction where more than one employee is involved, unless there are different circumstances, as in MBNA versus Jones, where the employee appeal tribunal held that different treatment for a colleague did not make the dismissal unfair, because the circumstances were not sufficiently similar. It's also important that a full record of the disciplinary process is maintained. This allows for managers involved in all stages of the process to refer to what has happened previously and provides evidence should there be any further issues. Employment tribunals will also want to see all of the documentation that was used during the process. So it's important to keep these documents available in case of a future claim. To try and keep the need for disciplinary action to a minimum, employers should proactively remind all employees of the internal rules and policies and ensure that everyone has access to the employee handbook and any written policies. This means that employees know what the rules are and can be a useful deterrent to future acts of misconduct. So, what is so important about following the procedure? Well, apart from ensuring that you are acting as a fair and consistent employer, should the action result in dismissal and a claim of unfair dismissal, the Employment Tribunal will be interested in three things. Was the reason for dismissal a potentially fair one? Was a fair, equitable and reasonable procedure followed? And has the employer acted responsibly in the circumstances? The third point is often known as the band of reasonable responses test. The tribunal will essentially ask whether a dismissal was within the band of reasonable responses available to the employer at the time, taking into account all of the circumstances. This essentially starts with whether there was a reasonable disciplinary investigation in order to allow reasonable belief in the guilt of the employee. Now, reasonable belief requires that at the time of the dismissal, the employer genuinely believed that the employee was guilty of misconduct, that there were reasonable grounds for that belief, and at the time the employer formed the belief, they had carried out a reasonable investigation. The entirety of the internal procedure will be considered by the tribunal, from who was involved to the time period it took to carry it out, to the notes taken, to the decision, to the right to appeal, etc. When considering how fair the process was, the tribunal will examine whether or not the procedure was carried out in a clear and transparent manner, whether or not you followed your contractual procedures, whether or not your process and the outcome was proportionate to the offence, and whether or not you followed a fair procedure that has been consistently applied. Without following a fair, thorough, and reasonable investigation process right at the start of the disciplinary procedure, this could, in effect, rule out any chances of your later decision being fair. If an employee feels they have been unfairly treated, unfairly dismissed, or that an act of discrimination has taken place against them, they generally have 3 months to lodge their complaint. This must initially be done through ACAS, who will try to engage both parties in early conciliation. If either or both parties refuse this, then the case may well go to the Employment Tribunal. At this stage, the colleague will complete an ET1 form, which will outline their case. Employees can only claim unfair dismissal if they have more than 2 years' service. This does not, however, prevent a claim of discrimination should they have any protected characteristics. Regardless of length of service, employers should always go through a fair process anyway. The Employment Tribunal itself is less formal than other courts, so they don't wear wigs and gowns, and is generally made up of a panel of 3 people: the chair, who is an experienced lawyer, and 2 lay people. They're non-legal, but experienced and respected in their fields. The claimant and the respondent will both give evidence, and witnesses will give evidence on oath and be cross-examined by the other party and the employment tribunal panel. Once evidence is given, both sides will then sum up their cases, at which point the tribunal panel will adjourn and make their decision. Once agreed, the panel will then inform both parties of their decision and why, usually verbally and then confirmed in writing. Normally, the case will be heard over 2 days, although for more complicated cases, this can be much longer. If an employer loses an unfair dismissal claim in whole or in part, the tribunal can require them to do one of 3 things. Firstly, reinstate. And this is where the employee gets their old job back and the employer back pays them from the date they were dismissed. They could ask them to re-engage. So this is where the employee is given a different job with the employer, but on similar terms and conditions. And finally, and probably more commonly, financial compensation. This includes a basic award, which is calculated on a set formula, and also a compensatory award for loss of immediate and future earnings. If the claim includes discrimination, then a further award for distress or injury can also be applied. The maximum compensatory award for unfair dismissal is currently 52 weeks gross salary, which is capped at £105,707, plus a basic award of up to £19,290. The median award in 2002 for unfair dismissal was £7,650. Now, there is no upper limit for cases of discrimination, although the average award across all types of discrimination in 2022 was £26,031. The highest for disability discrimination was £265,719. On top of these awards, the average cost to a company to deal with a tribunal claim is £8,500. Going to tribunal is an expensive, stressful, and time-consuming experience for all involved. It's far better to take the time to conduct your processes properly in the first place. And if you're not sure, get the right advice in early. Some key points for you to remember are: a disciplinary process must follow the ACAS code as a minimum. The investigation is an important fact-finding process to gather all relevant information. A disciplinary hearing must provide the employee with the opportunity to put forward their case. An employee has an absolute right to be accompanied by a statutory companion, and the fairness of the disciplinary process will fully be considered by an employment tribunal in a relevant claim. And that's it for the presentation. Thank you for attending, and I hope that this session has given you some insights into the fair handling and the importance of the disciplinary process. I will now stop the recording and happily answer any questions that you may have.